Welcome back to the Judgment Files. I'm so glad you're with us again. Today, we're tackling a case that, well, it's pretty much the case when it comes to figuring out what student rights actually look like in schools. Tinker v. Des Moines. Man, that name just brings up so many thoughts and discussions, doesn't it?
It really does. Even way back in 1969, the Supreme Court was wrestling with some seriously big questions about free speech on campus. And, the crazy thing is, those same questions, they're just as relevant today as they were then.
Totally. Okay, so before we get too far ahead of ourselves, let's set the scene. Tinker v. Des Moines. This whole thing started with, a group of students in Iowa who wanted to make a statement about the Vietnam War?
Right. December 1965 in Des Moines, you've got a mix of students and adults wanting to take a stand to protest the war. And their plan was pretty simple, at least on the surface: wear black armbands throughout the holidays, maybe even fast on certain days, make that silent statement.
A silent statement, though. Seems like that wasn't quite enough for the school administration. From what I've read, they weren't too keen on this whole protest idea, were they?
No, not at all. Something our sources really emphasize is that these students, John Tinker, Christopher Eckhart, and Mary Beth Tinker, they weren't exactly new to this whole activism thing. These weren't just kids messing around. Their families had a history of speaking out.
So this armband protest was more like a continuation of their values, their beliefs.
Exactly. Like, this was a conscious choice they were making.
Yeah.
And they were doing it knowing full well what the school's stance was. Because get this, on December 14th, the school principals, they get together and decide any student caught wearing an armband, they're going to be told to take it off straight up. And if they refuse, boom, suspension until they come back without it.
No messing around there.
Yeah.
And the students, these three, they knew about this rule before they put those armbands on.
Oh, yeah. They knew the consequences. They knew what they were getting into. But still, on December 16th, Mary Beth and Christopher, they go to school, armbands and all. John joined them the next day. And just as the school said, they were all suspended.
No warning. No second chance.
Nope. They went through with it. The students stayed suspended until after the holidays were over, after the time when they had planned on wearing the armbands had passed. And that, my friend, is where this whole legal battle really kicks off. The students, their dads acting on their behalf, decided to sue the school district.
Okay, so suing a whole school district, that's a pretty big move. What were they even basing their lawsuit on? What was the legal argument here?
They filed their suit under this part of the U.S. Code, Title 42, Section 1983. It's kind of a bedrock legal tool, right? It lets people sue state or local governments. School districts count when they think their constitutional rights have been trampled on. And in this case, their argument was pretty clear. The school's whole armband policy, those suspensions, they said it was a straight-up violation of their First Amendment right to free speech.
That makes sense. They wanted to express themselves, make a statement, and the school shut it down. Seems like a First Amendment issue on the surface. But didn't this go to a lower court first? What happened there?
Yeah, so first it went to the district court. And guess what? They actually sided with the school. Their reasoning was, well, the school board, they were just being reasonable, right? They were trying to keep things from getting out of hand to prevent any disruptions.
So the district court was saying the school didn't have to wait for things to actually get disruptive. Just the possibility of disruption was enough to justify shutting down the protest.
Exactly. And hold on, it gets even more interesting. There's this other case, Burnside v. Byers. The Fifth Circuit had ruled on that one. And they said, no, you can't just restrict speech because you're worried about potential problems. You got to show material and substantial interference, real disruption, before you can step in and squash someone's right to speak their mind.
Okay, so two different courts, two different standards. No wonder this case went all the way to the Supreme Court, right? They needed to sort this out.
You got it. The case went to the Court of Appeals next. But get this, the judges were totally split. It was a tie. So the district court's ruling stood, even though there wasn't a clear opinion from the higher court. That mess is probably exactly why the Supreme Court decided, yeah, we got to take a look at this. They granted what's called certiorari, which basically means they agreed to hear the case and settle this whole student free speech debate.
Enter Justice Fortas and the majority opinion. This is where things get really juicy, right? What did the Supreme Court ultimately have to say about these armbands and the First Amendment?
Okay, so Justice Fortas lays it out pretty clearly. First off, he says wearing an armband to express your views, yeah, that's absolutely a form of symbolic speech. And symbolic speech. It's protected under the First Amendment, just like straight up talking. To back that up, he brought up some landmark cases, West Virginia v. Barnett, that's the one about saluting the flag. And then there's Stromberg v. California, which involved, get this, a red flag. The point being, you don't have to say something to be protected by the First Amendment.
And that's key here, right? Because these armbands, they were all about silent protest.
You got it. Justice Fortas really hammered that home. He kept saying the students' protest was quiet, it was passive, it wasn't causing any trouble, and most importantly, it wasn't messing with anyone else's rights. He even went so far as to compare their silent protest to pure speech. And when it comes to the First Amendment, pure speech is like top-tier protection.
Pure speech. It's like the gold standard of free expression, right? No actions, just words, or in this case, symbols. And I remember reading this line in the ruling. It's so powerful. The court straight up said that students and teachers, they don't shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. That's huge.
I know. It's basically saying your rights as a citizen, they don't just vanish when you walk into school. That was a really big statement. But they also acknowledge that, well, schools do have some authority. They got to keep things running smoothly. But, and here's the kicker, Justice Fortas said, if a school wants to ban some form of expression, some opinion, they can't just do it because they want to avoid a little controversy.
So, like, just because the school thought the armbands might ruffle some feathers, that wasn't enough to justify a ban.
Nope, not even close. The court laid down a really important rule. They called it a standard that schools had to follow. They said a school can only prohibit some type of expression if they can prove that it's absolutely necessary to avoid substantial interference with school discipline or the rights of others. That last part's key. Substantial interference. They were echoing the language from that Burnside case, the one we talked about earlier, where the Fifth Circuit said you can't just crack down on free speech based on a hunch.
Okay, I'm following. But in this case, with the armbands, didn't the court find that there wasn't any real evidence that the armbands were causing, substantial interference?
That's right. Justice Fortas pointed out that out of something like 18,000 students in the entire Des Moines school system, only a handful, like 5, were actually suspended for wearing those armbands. They were like, where's the disruption? School's still running. Classes are happening. No riots in the hallways. Some kids, sure, they might said some stuff outside of class, but was it widespread chaos? Not even close.
And reading between the lines, it almost felt like the court was hinting that maybe, just maybe, the school's real problem wasn't so much the armbands themselves, but the message behind them. Like, they didn't want to deal with any controversy about Vietnam.
Yeah, I definitely got that vibe, too. The court pointed out that this whole armband policy popped up pretty much right after the school found out about the protest plans. And get this, there was even evidence that the school had tried to stop a student from writing an article about Vietnam for the school paper.
Wow, really? Talk about controlling the narrative.
I know, right? And here's the thing that really seems to give it away. The school didn't have a problem with other types of political expression. Students were wearing campaign buttons, even things like iron crosses. But the anti-war armbands, those were singled out. To the court, that smelled a lot like they were trying to silence a particular viewpoint, and that's a big no-no when it comes to the First Amendment.
So the court was basically saying schools can't just pick and choose which opinions are okay and which ones aren't. They can't be little bubbles where only certain ideas are allowed to float around.
Precisely. Justice Fortas actually used a pretty striking phrase to describe this. He said schools can't be enclaves of totalitarianism. He was making a point that students are persons under the Constitution. They have fundamental rights that schools can't just ignore.
So this wasn't just about armbands. It was about a much bigger principle of the right of students to speak their minds, even on controversial topics, as long as they're not actually causing a ruckus, as long as they're not stepping on other people's rights. I think they cited that Burnside case again here to reinforce that point.
Yeah, they brought up Burnside. And they also contrasted it with a different case, Blackwell v. Issaquah County Board of Education. In that one, students were wearing buttons. They were called freedom buttons, and they were using them to harass other students. It caused real disruption, and the court said, yeah, that's different. In Tinker, the kids were just quietly wearing their armbands, not causing any trouble. That's protected expression.
This whole idea of what counts as disruption is so fascinating. Like, where do you draw the line? But we've got to remember, this wasn't a unanimous decision, right? Mm-hmm. There were some justices who saw things very differently. What were some of the main arguments from the concurring and dissenting opinions?
Yeah, the justices didn't all agree. Even some of the justices who sided with the students had some interesting things to say. Justice Stewart, for example, he wrote this concurring opinion, meaning he agreed with the outcome, but maybe not with all the reasoning behind it. He raised a point that I think is really worth thinking about. He basically said, look, we shouldn't just assume that kids have the exact same First Amendment rights as adults.
That's interesting. So it's not a simple copy and paste situation.
Mm-mm.
The school setting changes things.
Right. He pointed to a case called Ginsburg v. New York, which was all about whether minors could access certain types of materials. His point was that sometimes the state has a good reason to treat kids differently when it comes to certain rights.
And that makes sense, right? I mean, kids aren't always fully equipped to handle every situation like an adult would.
Right.
But back to the Tinker case. Wasn't there another justice who agreed with the outcome but had some reservations?
Yeah. Justice White also wrote a concurring opinion. He was really emphasizing this ongoing legal debate about the difference between just plain speech and conduct. Like sometimes your actions speak louder than words, and those actions might not be protected in the same way. He was a little worried about some of the broad statements about free speech that had been made in that Burnside case we talked about earlier.
So even among the justices who thought those students should be allowed to wear their armbands, there was some nuance there. They weren't just saying kids can do whatever they want in the name of free speech.
Definitely not. Now, when it comes to the dissents, Justice Black, he was not holding back. He thought the court was way overstepping its bounds. He thought they were butting into an area where local school officials should have the final say. He was like, schools aren't meant to be soapboxes for every student whim.
It sounded like he was saying even though those armbands didn't cause outright chaos, they were still a distraction.
Oh, he was adamant about that. He brought up all sorts of examples. Kids making comments, teachers giving warnings, even this one math lesson with Mary Beth Tinker that he claimed got disrupted because of the armband. He was basically saying, this is going to lead to a free-for-all in schools. Discipline is going to go out the window.
And on top of that, Justice Black had a real problem with how the majority opinion used this reasonable test from older cases like Meyer v. Nebraska. Can you explain that a bit more?
Yeah, so in those older cases, the courts would sometimes strike down laws if they thought they were just plain unreasonable. Justice Black was arguing that that way of thinking was outdated and that the court in Tinker was like putting themselves in the shoes of the school administrators. He was saying, hey, the court shouldn't be deciding what's reasonable for a school to do. That's the job of the school officials.
And to make his point, he even brought up another case, Waugh v. Mississippi University, about fraternities being banned. What was his point there?
Ah, good catch. He was using that case to illustrate how sometimes the court does give a lot of leeway to states when it comes to keeping order in educational settings. In that case, the state said no fraternities allowed at a public university, and the court was like, okay, that's within your power. Justice Black was basically saying, see, we trust the judgment of those in charge, so why are we second-guessing the school officials in Tinker?
Okay, that makes sense. So he was all about giving schools the benefit of the doubt, trusting their authority. What about Justice Harlan? He also dissented, right?
He did. His whole thing was that school officials should have, like, maximum power when it comes to keeping things running smoothly. He agreed that, sure, students have rights, but he thought schools should get a ton of deference. Basically, he was saying that if a student wanted to challenge a school rule, they'd have to prove that the school was doing something shady, like intentionally trying to stifle a particular viewpoint. And since he didn't see any evidence of that in Tinker, he would have sided with the lower court.
So both dissenting justices, they were really focused on giving school administrators a lot of latitude, a lot of power to do what they thought was best for their schools.
Absolutely. They felt like the majority opinion was tying the hands of school officials and making it too easy for students to challenge every rule they didn't like.
So, wow, Tinker v. Des Moines, it's more than just about a few armbands, isn't it? It's like this foundational case that's still shaping how we think about student rights, about free speech in schools. For our listeners out there, what would you say are the biggest, most enduring takeaways from this whole saga?
Well, first and foremost, this case established loud and clear that students, even when they're on school grounds, they still have First Amendment rights. They have the right to express themselves. That's a huge win for student autonomy, for acknowledging that they're not just passive vessels in the educational process.
But, and this is a big but, those rights aren't unlimited, right?
Right. The court was very clear about that. Schools can step in and put limits on those rights if they can prove that a student's speech or expression is going to cause major disruption, like seriously mess with the learning environment or step on the rights of other students. That phrase, substantial disruption, it's key. It's the bar that schools have to meet.
And this whole case really forces us to think critically about what counts as real disruption versus just mild disagreement or discomfort.
It really does. Just because someone's expressing an unpopular opinion, that doesn't automatically mean they're causing a substantial disruption. And, even though they didn't win the case, those dissenting opinions, they still matter. They remind us that there are other ways to look at this balance between student rights and the need for order in schools. They force us to grapple with those tough questions.
Tinker v. Des Moines. It's more than just a history lesson. It's a case that keeps coming up again and again in new contexts.
Oh, absolutely. The whole question of what counts as substantial disruption, that's a debate that's still going strong, especially as we think about things like student walkouts, online speech, social media. Tinker gives us a framework, but it's up to us to keep interpreting and applying it to the challenges of our time.
I hope this deep dive into Tinker has given everyone listening a better understanding of what's at stake when we talk about student rights, about freedom of expression in schools. It's complex, it's messy, and it's incredibly important.
And you know what? This is just the tip of the iceberg. I'd love for our listeners to keep digging into this. Think about how the ideas from Tinker are playing out in the world today. Look at what's happening in your own communities, in your own schools.
Such great points. We'll see you next time on the Judgment Files.